Amen.
Thank you. All right. Let me welcome everyone who is present on the platform. We're doing this by hybrid, and I guess we'll do a few more like this. We did a good session on taking the bill this far. We need to complete it. It doesn't look like I can get it in the House in May. I still have a way to go. But I'd like to go to the matrix today. I think it looks thick, but it's not. Having glanced through it, there are not many things here to change. We have done the main ones already that bring some requests and proposals for change in Jamaica Rifle Association, Customs Agency, and the chambers of Mr. Champagne. So I'm going to try and go to the matrix today, but we'll have to return to weekly meetings, and I hope I can get the space. Tell the House we have to displace some people again. I think so far we have booked all the Thursdays, right? Yes. Up to the end of June. Yes, right? And we have booked some Wednesdays. And we'll send a outline to each member after today, so you have an idea, you can book ahead of time so we can complete this process. It has come a long way, but we cannot take a break now until we settle this. We took the Easter break, and I think most of the minutes are here. I'm not going to take them today. There's still a few more to be done, and then we can start putting the notes together for what we need to change, adapt, and get it ready for Parliament.
Not hearing you,
right?
DPM.
Are you hearing me all right? No. Are you hearing me better now?
Not sure if I'm the only one having the challenge. I think I saw
about to ask.
MPC Bill saying the same thing.
Are you hearing me now? We are hearing you loud and clear. Any other member? Any member not hearing me? Senator Sinclair? Senator Motley? Scott. Member Siblis? Something is happening and we're not hearing. Nobody's hearing us. Who is the technical team now? Morning again. Anyone hearing at all? Ooh. Oh no, what's happening? Where's your technical team? Nobody's hearing. No, let me tell you, I'm hearing loud and clear. Something.
I'm not hearing anything.
No, Minister, neither.
Not hearing.
No, neither am I. I'm hearing you clear, but I'm not sure what's happening otherwise. Who is the technician here? Try. Anybody hearing me now?
Hearing you loud and clear now.
Hearing you now, Doc.
Okay.
Hearing you now.
No hearing.
Okay. All right. Thank you. I was about to send a message, but yes, I've had it fixed. Thank you. We started with prayer. You didn't hear Mr. Richards gave us a very resounding exhortation, so we should be all in the right spirit now. I'm sorry I missed that, and I'm saying we are. Any apologies for absence, Anita? Senator Samuda, apologize, will not be here today. We took Easter break. We're at a good point, but we have a way to go with this bill, and we need to finish it. So I'm booking all the time down between now and June. We have lost a couple of days because of PAC, but I'm stealing some of their days as well. Today, I'd like us to complete the matrix. We have had we're not, some minutes already, but not all the minutes, so I won't take the minutes today. So I want to welcome all of you back from break. I hope you all didn't eat too much bun, Easter bun, and otherwise, and cheese. But we now have to reapply ourselves to getting this completed in good time. I'd hope to do it by the end of May, but it looks a little bit of a challenge. I said the minutes are not complete, although most of them are here. We'll do it next meeting. I'm going to try and complete the matrix today. I said we have looked at the areas that brought in significant sedition, the JRA, Customs, and the chambers of Mr. Champagne. Several of the individual ones related to the issue of permits for on the 21 and to take it down to 12, which I think we clarified before, so that shouldn't take us too much time, but we'll look at all the suggestions we have had here. The defense force made a few suggestions. I gather none of them are particularly far-reaching, so let's take the matrix. I'm going to invite Mr. Bailey to take us through, if there are no other comments. Mr. Paul Bailey is with us.
Morning, Chair, morning, committee. So we'll be going through the matrix of submissions for Firearms, Prohibition, Restriction, and Regulation Act. We just focused on the submissions that we have not already covered. So we'll exclude the Jamaica Rifle Association since we already considered those submissions, as well as Jamaica Customs Agency. So we had received comments from the public, one being Mr. Michael Todd. He had a concern surrounding the permit, the firearm user's permit, but that issue was addressed, and we had proposed to lower the age from 16 to 12 with certain conditions in place.
Mr. John Pierre Tipshan.
Yes, Minister. I'm going through the matrix to see if Mr. Todd had commented on any other provision of the bill. I'm not seeing any more comments. So we go on to the licensed firearm holders of Jamaica, LifeJam. Their first recommendation was that the Act should speak to a specific time that a firearm license application should take for a response from the board. This issue came up in our deliberations before, and we had indicated then that it would be quite difficult to specify a timeline or a turnaround time for the application to be either granted or revoked, in light of the fact that so much goes into the operations of the authority, specifically as it concerns investigations. So what we would do is just include a requirement of reasonable time, and then administratively the authority would work out or to see how best to increase their turnaround time, as opposed to including a restriction or a requirement in the legislation.
Currently we have a 90-day period.
90-day period as it concerns appeals, but not as it concerns the consideration of the application.
Yeah, let's.
Yeah. Mr. Chairman, if I might, morning.
Morning.
Hold on, let me see if I can get this video. Are you hearing me, Mr. Chairman?
Yes, we're hearing you loud. Go ahead.
Okay, thank you.
Senator, welcome.
No, it's a comment that I'm making. It's something that I think visits us, not just on this committee, but several times I feel a reluctance by the technical teams to hold an authority to a timeline. And I do understand the practical difficulty sometimes if there are delays in the system, but isn't it a better approach, and wouldn't a better approach be for us to have a timeline that the citizen can rely on, with the provision that the timeline can be extended for an additional specified period. And I ask that because there's so much uncertainty when you're dealing with a public entity in terms of when a license can be granted. And again, this doesn't just attend the Firearm Licensing Authority, but people can't plan. They can't figure out how to arrange their business. Somebody's applying for instance, a permit for a competition purpose, let us say. There's a need to know what the timeline is so you can arrange your life. And so I'm just asking for us to consider that approach as opposed to the open, reasonable approach, which is not usually reasonable, hardly ever reasonable.
Chair, through you, I'm wondering whether or not a good compromise would be for there to be some kind of ministerial direction given to the authority, in consultation with the authority, to determine what is reasonable in the context, and that be utilized at the administrative level as opposed to including anything in the legislation. So at the administrative level, at the level of the authority and their own operations, that they say to the public, to the applicants, to the holders of license and permit, that operationally we believe this application should take 2-3 months, as opposed to just putting something in the legislation.
I wouldn't be opposed to that, Mr. Bailey. I wouldn't be opposed to that. What I guess I am opposed to is an open-ended approach where a license can take 1 year in one case, 3 months in another, 18 months in another. An approach that says, this is the time. If this time expires, it must be for good reason. So if that can be done operationally and that can be published to the citizen, I'm sorry, I didn't have my video on, and that can be published to the citizen, then I would be supportive of that. Thank you.
So would I be given an undertaking to ensure that as part of the protocol given to the FLA authority, right? The members that support that will make sure that is done. It becomes a part of the permanent policy or outline to the administrative policy to the authority. But it is a real problem. And sometimes somebody applies to government for a permit and it takes an enormous long time. And when you go, it's just lying around. We have to find a way to correct that. I mean, the object of government is to overcome that by increasing use of technology, which is digitization and so forth, which should change it. And one of the holdup, for example, is just the NIB record. And they need to ensure there's a satisfactory one. So,
Chairman,
go ahead.
Just to say, while I share the concern raised by Member Golding Campbell, we have to be careful what we specify in the law, because you do not want to put your authority in a place where they actually breach the law. I recall the FLA indicating to the committee that they now have a software which will enable an applicant to track the stage at which the processing of their application is. And so while I appreciate the concern about the inordinate time that often attends upon completing processes with the authority, I would not be in support of specifying a time frame in the law, but certainly administratively from an operational standpoint, bearing in mind that they can now track the different stages, that there would be the more appropriate place to indicate when an applicant may be able to hear. But given what is involved in completing, in vetting an application, there are matters that may take longer or shorter time. So my point really is that while I generally agree that where appropriate, timelines should be specified. The law is not always the place where that is to be specified, because you do not want to end up with a breach of the law. Other consequences flow from that. But every effort should be made for efficiency and the proper serving of the public to ensure that things are done in as timely a way as possible.
That was Mr. Bailey's decision to do it administrative, and we accept, I think. SG want to say, and then Senator Sinclair. SG? Thank you, Minister.
Yes, thank you, and morning to you, Chair and members. Just to indicate that I don't agree that it could be achieved by ministerial direction. So clause 25 speaks about ministerial directions being given to the board, and that provision is very similar. I was going to say identical, but it's very similar to a provision that has been judicially interpreted. When it says that the minister gives directions of a general character, it doesn't mean that you can give these kind of very specific directions. But I don't think if you're doing it administratively, I don't think you would have to rely on ministerial directions. There should be other governing protocols within the authority or the board under which they would operate, but just not done by way of ministerial directions. The court has already ruled on that. Thank you.
Thank you, SG. Senator Sinclair.
Thank you, Mr. Chair. I want to just put on record that I am in full agreement with Senator Shereen Golden Campbell on her proposal. And I am one other aspect of why I would want for something to be stated, whether it is in the Act, and if you're against it being stated in the Act, there is a regulations that fall under the Principal Act. At least there are regulations that exist presently, but that it places a timeline on the applicant who may have been denied or whose license was revoked. There's a timeline that is placed on that person of 21 days in doing something, in appealing the decision that has been taken by the FLA. But they can get an extension of time. So I can't see why, on a principle of mutuality, that should not apply to the FLA. And if persons are speaking about efficiency in government, you give them a 6-month period within which to respond to an applicant to indicate. And during the process, there is a need for more time, then they seek additional time. But I think there needs to be some timeline placed on it. Persons presently have been waiting 3 years just to hear from the FLA as to whether the application is approved or not. And I believe that if you leave it open-ended as to what is meant by reasonable time, I mean, it can be given, it depends on the circumstances of the particular case. But I believe that that is a door if it is left open to some amount of corruption, because somebody is going to start trying to contact persons to see how their matter can be expedited. So I just want to give my support to the comments of Senator Golden Campbell on that point.
May I just, Chairman, through you, just to clarify, is the request in respect of advising the applicant that the application has been received and is being processed, or a time frame for the application to be dealt with and a decision taken on the grant or refusal of the firearm? Because my understanding is that going forward, that the applicant would be notified and has a means by which they can ascertain the stage at which the application, the processing of the application is. So just, to clarify what the concern is, because it's a different set of circumstances, different set of issues for response to be given in respect of the stages, as opposed to a definite time frame within which to take a decision.
My question,
sorry,
Minister.
Senator, can I ask? Let me get that clear, because two things I'm going to be. I
was just clarifying the question that I asked. I thought that was her question.
No, I was asking you to clarify. I want to get some clarification on your comments. Are you referring to a response to the applicant or a timeline for them to make a decision? Because the response, we can certainly put a timeline on. If they apply, they should get a response from the FLA within a very reasonable, 21 days that they put for application. It would be a reasonable time, because it really says that I have received your application, examine it, etc. That's a response. And I think a timeline should put on that. Nobody should apply to the government, any government agency, for something and sitting around waiting for 6 months to hear what is happening. Now, in terms of the decision, something. So, Senator, what are you looking at both things or what?
Chair, to be very honest with you, it really encompasses both issues. And I understand Minister Malahou for it to be saying that the FLA currently now has in place a system where they're advising applicants. I'm not remembering the specific submission and discussion on that day. But having said
it's a software. It's a software that you can track to see where your application is, what is holding it. It has been considered by the board. They are waiting NIB, or they are waiting X or Y. That's what they're putting in place. I think it should be in place now.
Which would be very useful. I don't know if anybody ever buys Domino's pizza online, but you can see when it goes in the oven, you can see when the bike man leaves with it, and you can see when it's on its way to your house. And it allows you to be standing there waiting at the gate when it comes. So that's useful. However, my concern would be in relation to time and in relation to the point that Senator Sinclair made, is that if you're looking at something that's telling you awaiting a report, and for 2 months you log in and you're awaiting a report, it still doesn't give you any idea as to the timeline when you'll be moving from waiting from the report to the report being considered. And I appreciate that the legislation is not perhaps the appropriate place to put this. So what I understood Mr. Bailey to be saying is that it's something that can be done administratively. And certainly a board of the authority ought to be very concerned about how, the timeline and time frame in which applications are processed. And I'm going to share an example with the committee chair and why this is so important just in the context of how our public entities operate. I have had the experience on 2 different occasions of foreign investors coming into this country and applying for licenses to do business, not in firearms, but to do business. And the application process after they invested monies was so long, drawn out, and indefinite in terms of when it would be completed that they abandoned the monies that they spent in Jamaica and left. Now, what I'm trying to say is that generally speaking, and in particular in relation to the firearm, all the security concerns that we consider when we're looking at a license, if you have this long drawn-out process, as Senator Sinclair says, there's just a lot of room for people to get involved in the system to move a man's application. And it happens all over public entities. I hear people talk about it all the time, right? So let us be honest about the dangers that can cause, and let us try and see if we can raise the standard. So if it is administratively, it has to happen, I'm fine with that. I'm not insisting on the legislation, though I believe Senator Sinclair perhaps holds a contrary view in relation to where it should go. I think he wants to see it in some sort of permanent or, reliable place that the citizen can draw for. But he can speak to that. Chairman,
the issue is, I don't think there's any debate in the issue that there has to be some certitude given. So the first thing is, as I said, there must be a response at a given time. In terms of completing the application, Mr. Bailey said it will be done administratively. If what I need to know, if once the administration, what guarantee I have that to be done? You know, it's not a ministerial directive, as indicated by the SG. After this committee makes the decision that is administrative, what guarantee I have that this will be done with certainty it will be done, and that a reasonable time will be given? Out of legislation or the regulation, the board will be instructed so to do.
Chairman,
I'm seeking guidance.
Chairman, so again, the discussion has clarified a number of things. Before we come to the time frame, I think it is quite permissible to set a time frame after the completion of a determination has been made of the application, to set a time frame within which the decision is to be communicated. That's a different matter from setting a time frame of when the application itself is to be considered, given that there are different stages in the process. And depending on the applicant and the background and the kind of checks that are required, you may have a longer or shorter time. But just to clarify that when you have the software that enables tracking, an applicant to be given a tracking number, and they can actually log on and track the progress at different stages, that helps to alleviate the concerns that persons who are dealing with the authority have. I think going beyond that once an application has been processed and determined, there should be a set time frame within which the decision of the board is communicated. I think the board can set all of those policy around time frame can be by way of a board decision and a direction to the CEO, and that could be posted on the CLA as part of communicating with an applicant.
Minister, there are three timelines being referred to. First, the board must respond and indicate that they have received their application to be considered within that limited time. That's easy to do. The conveying of the decision is also pretty straightforward. The concern of members, one of the concern of members is that it can be an inordinate delay in processing, and sometimes there's no reason. Now, once it can be tracked digitally, there is no challenge there. You can follow, but there is the problem is not communication with the decision unit. It is really now the processing, the time it takes to consider the application. It's more easily illustrated when we look at the appeals we have been dealing with. Appeals were 3 years behind. So individuals were appealing within 21 days and have to wait 3-4 years to get an answer. No, that is what you don't wish to transfer into the process. They do take a long time, and some kind of time frame has to be given with the possibility of extending. I think it's question. I think I prefer the administrative line, but I just want to be assured that when we make a decision along here for administrative, it will be done. How can I?
Well, Chairman, I mean, so there is a way that institutions are held to account. I mean, we have a framework in respect of the authority, the board, the functions, who reports to whom, and ultimately a reporting up where it matters. I think in the past, what has happened based on reports in the media and persons speaking of their experience is that an application would be made and nothing happens. It's perhaps sitting on someone's desk. There is no communication. Months turn into years. and nothing. And then perhaps it requires a bribe or an intervention to clear the way. That is what you don't want to have happen. There has to be a structured way once applications are received that they're dealt with in as timely a manner as possible. And you move from stage 1 to stage 2 to stage 3. And that the order in which the things are dealt with are communicated to the applicant so they know, and with the software, they would be able to say it's moved from step 1 to step 2 to step 3. And after step 3 is completed, then it would go back to the board for consideration. A decision would be taken and the decision is communicated. But I think if we were to summarize the concern, DPM, is to ensure that matters are not just left lingering.
Minister,
that once the application is received,
no, there's agreement, it's how, what I'm seeking, I need assurance that what we have agreed to will be done. We are saying the same thing. We have agreed there has to be some reasonable assurance given to the applicant that they will get a response at a certain time. Now, I'm trying to get, whether you put in the law or you do the administration, what means, I just need to be advised that what decision we take will be executed if it's not in the law and how it will be done. I think Senator Sinclair want to come back in, Minister, who had a difference from your point of view. Senator Sinclair and then SG.
Well, all I was going to add, I was seeing the CEO of the FLA at the opening in St. Anne's, of the office in St. Anne's. And he spoke about the improved efficiency of the FLA in respect to if you make an application, you actually can get, because they have connectivity now to GACF and other departments in government that they may need to get information from, so they can get it in a jiffy. I can't see why it is that Minister Malawi Fort is somewhat reluctant for some time frame to be put in.
No reluctance at all, Senator Sinclair. It's just how it is done and where it is done. It's just the how and where it is done.
Fine.
In the
same way that the timeline for the applicant to do certain things is placed in the regulation, can't the timeline for the FLA to provide a decision be put in the regulation? And if, with a proviso that in the event that they need an extension, they get an appropriate approval for extension from whether the board or as the case, wherever it is. But I believe that some timeline must be stated and they must be held to it.
Let me hear from SG before. Go ahead. SG always brings us into.
Okay, thank you. So my intervention was just to try and help the committee decide on the proper placement of this requirement. And you would want to consider whether the provision should be enforceable and whether there should be consequences. That will help to guide the committee as to the better place to put these kind of provisions. If you leave it administratively, you're looking at the consequences, probably disciplinary, perhaps, and that would need to be structured, but that would be left to the board. If you're looking at putting it in whether the act or regulations, then you have an opportunity to address enforcement and consequence. As it relates to an extension, no, someone would have submitted an application and it's not dealt with in a timely manner. But you would have to have an extension because you want the application dealt with at some point. So I'm just not clear how that extension provision would work in a situation where you don't want to deny the person having their application being reviewed. So I think that needs a little clarity as well as the mechanism for that. Thanks, Chair.
Thank you, SG. All right, be advised, it was administratively, can be done. Is that the agreement? But there has to be some time frame given to go from recognition of accepting application process and then informing the applicant of the time. The elephant in the room is, of course, the processing time. Yep, go ahead, Senator.
I'm actually not so clear that is the only elephant. I seem to get feedback that suggests that the application process takes place, but then the decision process is very lengthy, and there are extreme delays there as well.
So, Senator, you're saying to get the decision, it can take a long time?
Yes, that's the feedback that I have gotten. And I'm saying perhaps, Chair, that maybe just for the team to kind of take a look, analyze, where those delays are before we kind of decide how you would draft that.
Well, what I'm saying, Senator, the question of recognizing an application don't need to be researched. If you get an application, as a citizen application to a body, they should respond within a very short, almost immediately. So
agreed with you, Chair.
There should be no delay there. And once a decision is made that you are fit and proper to get a license, there should be no delay in that either. Mm-hmm. If there's a delay now, then that's grossly inappropriate. What we have to examine is the timeline it takes to examine the application, and where we make that administration, there should be some time frame given, but I think I'm inclined to go administratively. I just want to be assured that when you say administratively, a reasonable time to put in place.
Chairman, just seeking clarity through you to the learned Solicitor General in respect of the suggestion. I mean, I support disciplinary action where there is a requirement to act within a time frame and there is no action without reasonable excuse. But who would be disciplined in those circumstances and by whom? Through you to the SG.
Well, Minister, as you asked, if you look at the existing structure and what we are carrying forward before the SG comes in, this is why I'm inclined to go to administrative support, because the issue of who is accountable for the delay is who you'll have to, is the question you need answered. Now, the board members will tell them meet every week. They didn't get the matter. They may refuse to consider who do you hold liable. The CEO sends out the investigator, or he awaits on CRO. So there is some, you'll have to look at each step, and did they sit on the request to the CRO too long? Who did that? It could become quite complicated once you get into the question of the accountability. But I think you should put the time in administratively, and then it will allow the board to look at holding the technical people accountable. The board is going to be a different ball game.
So one of the challenges I find in dealing with government DPM colleagues is that nobody wants to say whose omission or failure has resulted in the problem. I mean, I never cease to be amazed that even persons in the hierarchy who are to hold, by virtue of their supervisory role, to hold subordinates to account, there is such a reluctance to say, where did the omission occur? Where did the delay take place? And because the place to spot a fault is exactly where it occurs. And when individuals fall down and they are not addressed, it becomes a systemic issue. Well, and that is why I'm saying we may not be able to clarify all of it here, given the work that is before us in the committee, but it is certainly something that has to be looked at.
No, we can
So
proceed.
duties are assigned to office holders, and we should be able to say this is where it is at this stage, while under the watchful eyes and in the hands of this particular officer that something went awry. Instead, what you find is just a cover-up. Nobody wants to say where, and what we have as a result is just systems that become inefficient, that serve very poorly, and nobody's held to account.
No, Minister, we don't need to delay the decision because we know how it operates. I think it's real, as I said, the decision whether we go with an administrative issue, and I just want to be assured if we take that decision, it goes in, or whether we take it in the regulations. And I'd be advised there, because the steps are clear. You know, once its application is made, there are a number of things to be done, and the CEO should report to the board. The only person you can delay it after that is the board, and the board is what the government appoints and will be accountable to the government and represents the government. And you can't, but in terms of the administration, it's very easy to decide to find out where the delay is, and if there's an administrative protocol that is breached, the discipline is attached, it's done. You know, if the person sat on the desk for 2 weeks before they send it to the NIB, then that person is held accountable. The NIB may tell you now they have a challenge, but they can always explain their position as well. They too are improving their technology, their use of technology, because the demand on them is higher. And we have invested recently. We have to invest again to cut the timeline for these things. Clearly, when they're investigating homicides, they will be more inclined to follow to do the investigation and record keep for those people who are implicated in that kind of activity versus an application. But they can give timelines, and if they get that time. But again, you can hold them accountable, because you know when it went there. So I think it's really, the decision is, do we want an administrative or regulatory? I'd be advised, I said. Want to put
Mr. Chairman, may I make a suggestion? I've had my hand raised.
Go ahead, Senator.
Could we find another solution? And the one I'm suggesting for consideration is if an applicant does not hear one way or the other a decision from the FLA within a reasonable time frame, then that is deemed to be a denial and allows the applicant to appeal to the review board. Then the review board would be in a position to hear from the FLA why they have not responded to the applicant within a reasonable time, and make a ruling whether the FLA is being reasonable or just being tardy in their response.
I just pick up from the point that Senator Bunting just made. I would go the reverse. And let me put a preface to that, the point I'm about to make. I concur with much have been said about the lack of customer service and efficiency, so I won't repeat that because it's a known fact. I believe that in this legislation, we have an opportunity to legislatively try to change that culture of non-responsiveness. So the flip side of what Senator Bunting proposed, which in principle I generally agree with, rather than say after that specified time that they don't hear, they have to automatically approve. Because if that is placed on the entity, I swear as night follow day, they will give a response not to make an approval go through that they object to. But to then, out of doing nothing, it's considered not approved, and then subject the person who applied, the applicant, to have to go through an appeal out of ignorance of not knowing what transpired with the application. We should switch it and put the obligation and the burden on the entity to respond.
We're adding a number of things to it. I would recommend that I'm inclined to go with an administrative response. And what I was trying to get is, how can I be assured that when I say administrative, the decision gets transmitted from here to what comes out in the end? That's really what I was seeking an answer, because administrative will also have disciplinary procedures to follow if the people fail. So all that has to be included, which was raised by both SG and the minister. That I'd expect, as we improve the system, to go into regulation is a little bit tedious. I mean, in fact, itself renders, once it is efficient, then the regulation becomes null and void. Administrative, you can adjust the administrative regulations, so the administrative requirements, as the system changes and improves. So once we say it here, it gets put in, the board has to put that in place, I'd expect. So what we're putting in the law is that the board is required to provide that guidance administratively.
Minister, I think, if I may, I think it's going to be extremely difficult based on...
all right,
right.
Let me come back again. I'm a layman here. I'm accepting a chairman as layman. You know. And whether the members are on the team or not. I'm just asking, I'm in agreement we have to put some time limits. We may have to put some, even hold them account, whether we take, whether Mr. Bunting says they get the license automatically missed. But what I'm looking at, if I go with administration, how am I sure that it's going to be put in there? What assurance can I have? Should I have, what assurance do I have that once we decide here it's administrative, it will go into the administrative?
Mr. Chairman, I'd just like to clarify my position. I was not saying to give the license automatically. I think that was Mr. Jackson.
No, not you. Your member said that. Your counterpart said.
I hope not. That wasn't it. Member Jackson.
I am saying that if the
I hear loud and clear, Mr. Bunting, and I think that's one point.
Does not get a decision within a reasonable time frame that it be deemed a denial and that he can therefore appeal to the review board. That is my
I got
position.
that clear, and and we have to clear the review board. Open another board. They're 2 years behind, so that's just among the reasons I'm looking at. I'm seeking assurance that we can put into the administratively or regulation the requirements for the authority set to respond within a reasonable time, and put some limits on that reasonableness.
Why am I a little bit...
CPC has her hand up.
Minister, please. Go ahead, Minister.
The CPC has her hand up. Just...
Go ahead, Ms. Grant.
Thank you. Well, I was just wondering how to translate practically what has been said, because even if we're still referring to a reasonable time, taking Member Bunting's suggestion, it would still beg the question of what would be reasonable in the circumstances. So I'm wondering if the committee wants to consider going in the direction of requiring, perhaps in regulations, the authority to establish some sort of service standard framework where they would communicate what would be considered reasonable timelines for a decision, and then require them, where those timelines are not being met in the case of a particular application, to notify the applicant that a longer period would be required.
Thank you. No, I think we're in agreement there. What I need to know is where we're going to put that. Let me go back then. As I said, we need to put in there a framework with a timeline for response. Where do we put it? If it's administrative, how do you get it in the administrative direction that goes out? Are we going to put in the regulations? What's the best route? I'd ask your CPC.
Yes, Chair, I was suggesting that the regulations could require the authority to establish a service delivery framework and publish that on its website, which would establish reasonable timelines and require them, where those timelines are not being met, to communicate to the applicant that a longer period would be required in the particular.
Thank you, CPC. That's what's been asked all along. That's what we need. The other things we can discuss otherwise. That the authority be required to provide to provide a framework for timeline response on all the issues that relate to application, and that will be put in that is what will go in the law, in the regulations for the authority. Thank you. Really?
We're now going back to the matrix of submissions. Continuing on.
Chairman, I see that the SG's hand is up, Chairman.
SG?
Yes, just on that same point, what would be the consequence for non-compliance?
If the board is required to put in place the the framework, they would have to indicate what disciplinary action they will take against the members who breach that.
Because it's looking to me as if it's more something like judicial review, meaning if someone is just waiting and not getting a response and the matter is not being heard, and if you don't put any other consequence in that framework, the person is then forced to go to court.
No, well,
so that's what I'm asking, what consequence would you build in as well?
No, no, I'm not getting it. If the person does not get any response, what is their... I didn't get that clearly, SG. Repeat that for me.
Okay, so I was asking about a consequence for non-compliance, and also indicating then that to me, it suggests that the recourse for the applicant then would be something like judicial review. Because if you don't put in a specific sort of sanction, then what happens when you do have a situation where the person is just waiting and the application is not addressed?
And Chair, may I I've been mulling over the point that the SG made, which is who do you sanction? If it's administrative and there are sanctions to be applied, how do you determine who is to be sanctioned?
Poor Member Williams want to comment. No, in the case of the requirement for the board to put in place the requisite time frame, sanction for the staff in the administration, the administrative staff, whichever member of the authority does not carry out their duty on time, the board will have to hold accountable, and that's fairly easily traced. I think I get from the SG now, however, even if that is done internally, they are not aware, and if the matter is delayed over a very long time and a reasonable length of time, what recourse does the applicant have? Am I right, SG? But you see,
that's correct.
Right. So you see, the issue of the accountability internally is pretty straightforward. You have a body, and you have a whole team of people employed to the administration. The authority, once they lay out the rules, will have to hold each officer accountable at each point in time. So that's not difficult. No. It's the question now, I think what SG has raised is another issue. If the authority does not inform the member what they're doing and what is called the delay, and the delay exceeds the reasonable time, and I think that reasonable time can be defined. It will have to be defined by the board. Then what recourse does the applicant have? Should we include that? Should we include something along those lines? Member Williams.
I would just say, Mr. Chair, with your permission, in relation to the AG's concern, what it would seem to me, what will happen eventually is that by virtue of inserting the timeline, the framework in the regulations, it would now be strengthening the applicant's position in relation to judicial review. Because
I think don't continue. The board will be required to provide timeline. And that will vary, but I want the board, it will vary depending on the level of improvement take place in the board. Once you have you digitize that you can track your activity and the system improves, then it will have a shorter timeline. If it's, until that is installed, you may have a longer timeline. So I'm comfortable with it being put in administratively and that the board is required so to do. The SC has raised the issue, what recourse does the client have? I think the suggestion by Senator Bunting maybe could be examined before we go to the judiciary. It's not over today. That if they don't get a response within a certain time, they could send a direct appeal to the review panel. We should have to respond within that immediately.
Yeah, I don't know, but just to understand me clearly, I'm not saying we are going to, or we will be obliged to insert any recourse in the regulation to judicial review. In other words, we are not providing a remedy, but there is nothing to stop an applicant after reasonable time has expired to seek redress.
The current situation is that they send them back to the review panel on the appeal. Minister Fort.
Yes, Chairman. I think the discussion has been fruitful, and perhaps it could be summarized by way of recommendation that a service standard framework be developed for promulgation through regulations to include set timelines which should be communicated, and also consequences for non-compliance with those standards. And then you can determine the who, the what, and the wherefore of it. But I think the broad principle has been agreed that given the concerns around efficiency, failure to communicate, all the problems of the past, that a service standard framework should be developed and promulgated, should be developed and specified by way of regulations and then published on the FLA website. And timelines should be set and communicated, and where there are failures to comply with the standards that are prescribed, consequences should flow.
Well, that's summarized. That's understood. I don't. Well, the only different. The suggestion was that the board be instructed to provide those service standards and publish them, and hold them accountable. So.
Well, yes, Chairman. The details can be worked out.
Right.
But the real point is that the gap will be addressed in a meaningful way.
No, we are in agreement in it. It's just to get the instruction correctly. I don't think we get that far yet, right? I know, but I think well a bit, and you know, what we'll have the right to do is to review whatever service standards are set, and if we have to re-intervene, we intervene. I think the people who serve on the board usually are looking towards usually people have an interest in moving the system forward. If you're part of a negative, whatever a problem. No, the discussion, I agree with the Minister, was very useful, but I think the general issue of ensuring that service standards established short government is a major issue, and we'll just use this opportunity to lay this down for the Firearms Authority.
Agreed, Chairman. Agreed.
Right.
You know, this piece of legislation breaks new ground on many fronts, and I think it can, I believe, as one member said, be appropriately used to ensure that some of the issues, insofar as they relate to the entities under the law, under this particular law, are addressed.
Yep. Thank you, Minister. Right, Mr. Bailey is over. I think the next item on the matrix we'll look at, the JDF has asked us to provide for control, delivery, and weapon trafficking to combat. Provide for control, delivery, and weapon trafficking to combat weapons trafficking. What was Sir Richards, this particular request from the Jamaica Defense Force?
Minister, when we had initially looked at the legislation, we thought this was something that could be handled administratively. However, in discussions with the operational entities and in looking at some other pieces of legislation, this is something that, from a policy perspective, we are in agreement with, and we will therefore be having some discussions with the CPC in respect of including such a provision to actually define control delivery and the competent authorities who could actually use control delivery as an investigative tool. We looked on what Trinidad has in their legislation, and I think it's just a simple provision to say that the use of control delivery shall be accepted in a court of law. So that is something that we will probably have a discussion with the CPC about.
And the face of it seems very reasonable to me. We should take steps to include it. Any questions? Minister, comfortable?
Sorry, DPM, it went out. I didn't hear all of it. I heard the part of looking at the Trinidad model. I didn't hear what went before that and in discussion with the CPs.
The thinking was that it was adequately covered in the existing legislation. And
what is the it? So sorry.
It is to provide for control delivery and weapons trafficking, to combat weapons trafficking. Essentially means that if the Coast Guard picks up a boat at sea, you can then replace them with fake weapons, or you can in fact allow for the continued delivery. But I said it's controlled delivery, so you can arrest the individuals, identify those who are receiving it, and arrest them as required, rather than just, you have to provide for that in law, rather than once you intercept, no, you have to take it off and detain them. So by understanding, it is required to be include the law for allow that to be done adequately and properly. The outline in the matrix is quite detailed in terms of controlling transnational organized crime involvement in illegal trafficking. So the recommendation that specific provision should be added that allows for control delivery where the illicit items are removed and replaced with either fake items or some other items sufficient to provide a prima facie belief that the illicit item is still present. The bill should then have a specific provision stating that removal of the illicit item from a shipment under control delivery will still amount to possession in law of the item that was removed from the surrounding circumstances, so that they can be adequately prosecuted. Apparently, your very smart colleagues, professional colleagues, have, where the sons that exist, have been able to get their clients off when this is done. So I think it needs to be included.
Chairman, I've looked at the recommendation and I appreciate the issue that the JDF would want to have addressed in the law. So preliminarily, I have no difficulty with it. Of course, it would have to be more closely looked at to ensure that it is properly provided for.
Mr. Chairman, I would suggest we postpone further discussion on this. Since it's been accepted policy-wise, let's just wait until we see the actual drafting of the clause.
Accepted, Senator. We can move on to the next. We did consider the Jamaica Rifle Association, all of that before verbally. Counter Bar Association, Mr. Bailey was.
So Cornwall Bar Association had recommended that there must exist a framework of accountability for defense witnesses who present false evidence to the court, that the focus on particular kinds of offenses has tended to have a negative impact on particular communities, and that the bill as proposed has the potential to cause erosion of natural justice as a part of the plea bargaining process.
Minister, translate that for me. Honorable Leader.
Sorry, BPM, I seem to be having a slight audio issue. Mr. Bailey, would you be kind to repeat? I see it.
The Bar Association, if you might hear me more clearly, there must exist a framework of accountability for defense witnesses who present false evidence to the court, that the focus on the particular kinds of offenses has tended to have a negative impact on particular communities, that the bill as proposed has the potential to cause erosion of natural justice as part of the plea bargaining process.
Well, my understanding is that because the consequences of a conviction under the law are so severe by virtue of the penalties involved, anyone who tells a lie on someone which results in a conviction is what they're seeking to address. We do have offenses for perverting the course of justice. We do have perjury. I'm not sure what exactly they're saying for defense witnesses who give false evidence to the court. I mean, any witness who gives false evidence I mean, evidence is given under oath. And speaking falsely under oath, one perjures one's self. So any form of false evidence would erode justice, because, you have to be satisfied on proof beyond reasonable doubt that an offense has been committed. And it is always a travesty to have someone convicted of an offense for which they did not commit, even though they are found guilty by virtue of evidence, convincing evidence presented in the court. So I would probably want to hear what it is that they have in mind that is not already covered by law, even though it may involve initiating a prosecution of those persons where it is established that they have in fact given false evidence.
Are they seeking to increase the penalties for such? Because it is covered. I don't think you need to. Perjury in court is perjury. That's already covered by law. Perverting the course of justice is established. So I don't know if the members think you should increase the penalty for that if it relates to a firearm. Minister, is that what that's the only thing could be emerging?
Well, they say in respect
I don't know what the penalties are now. Are those penalties now of any significance? Is it that if you perjure the court, you get charged $4 like the gentleman who fish in the harbor, or is there some significant penalty for so doing? If there is, then there wouldn't be need for any further adjustment.
Let me pull up the Perjury Act to remind myself, Chairman.
Mr. Chair, if it pleases you, I'm just wondering if the reference to defense witnesses here should really, if the intention is to state prosecution witness. Because in light of what Madam Asia has said, and it is...
Well, I'm assuming that it applies to both sides. If a person in defense tells a lie and the person gets off, then he should be held accountable. But that's also perverting the force of justice. So what's the penalty for that? Is there adequate penalty for that? In other words, if an officer comes to court, and the officer who is part of the defense and tells a lie so the person gets off, that's the implication here. But do you have current laws?
Currently, Chairman, Section 4.1 of the Perjury Act specifies that every person who, being lawfully sworn as a witness or as an interpreter in a judicial proceedings, willfully makes a statement material in that proceedings which he knows to be false or does not believe to be true, shall be guilty of the misdemeanor of perjury, and on conviction, on indictment thereof, liable to imprisonment with hard labor for any term not exceeding 7 years, or to a fine, or to both such imprisonment and fine.
That's pretty good. Right. And in this case, the person could be, and I expect that...
And it specifies that the expression judicial proceedings include proceedings before any court, tribunal, or person having by law power to hear, receive, and examine evidence on oath.
In this case, too, wouldn't this, if this is a defense witness, be perverting the course of justice, and that also would carry its own penalties?
Well, when it says that lawfully sworn as a witness, then it covers any side.
So, well, we can ask Counterbar to submit further comments, but it would seem to me we have covered, the matter is adequately covered in law already. Thank you, Minister. Proactive Jamaicans, what are they asking for?
So Proactive Jamaicans, the recommendation, they're saying in relation to data protection, multiple sections speak to data and wording unique to this act is used. Data should be stored in accordance with the Data Protection Act. There is no need to come up with different wording for the standards.
Perhaps the Madam CPC could assist in a response to that, Mr. Chair.
Minister.
I'm saying perhaps the CPC could assist us in responding to that.
Yes, I wait the CPC intervention.
I'm not sure if I understand what is being requested by Proactive Jamaicans. They seem to be asking, I could be corrected if I'm wrong, for a provision to require data to be stored in accordance with the Data Protection Act. But the Data Protection Act is of general application, so it would apply to the extent that the Firearms Authority is a the holder of data for any individual. So there's no exemption here exempting the Firearms Authority from the provisions of the Data Protection Act, so it would apply.
So there's no need to pursue this any further. It's covered already. Mr. Boucher says establish a condition that allows for fines to be adjusted based on economic conditions. Well, I think fines are, where fines exist, they can be adjusted by the ministry of bringing them to affirmative resolution. So that's not a big issue either. Mr. Wright.
So Mr. Wright's recommendation is that all licensed firearm holders should be given a form of identification similar to a voter's ID that should be presented whenever they come in contact with members of the police force to avoid
Well, we are moving toward national ID, and I'd expect at least one of the, it's voluntary, but one of the minimum requirements is expect to get a firearm license, you should have an ID.
But Minister, when I last look at a firearms license, it's in a similar form to what the new firearms licenses are in similar form to, say, the driver's license, the little card size, unless I'm wrong. But
no,
when I last looked at one, that's what I saw.
I'm also saying that at least one of the minimum requirements to get a firearm license, but at least we're not making it any more difficult, we're making it easier, but they should have an ID, and you're moving toward a national ID. I would be unhappy to giving a Jamaican a firearm license if he's not willing to have an ID.
That's not what I understand that to mean. It's a form as opposed to a booklet that it used to be in time past. It's now in a ID form. Unless I am misconstruing the concern raised and the recommendation made.
But, okay. It's today 12-year-olds involved in sport shootings. That has been dealt with.
That has been dealt with, Minister.
Mr. Bailey, continuing to next page, we get to recommendation for the appointment of a nominee for ownership on the death of licensed firearm holder. That's the next one. Well, we did that in the Rifle Association.
So the next general recommendation coming from Proactive Jamaicans. They say, in relation to offences generally, mandatory minimum sentences have been found to produce instances unanimously viewed by society as harsh. We suggest that the Parliamentary Council be directed to draft and include a clause by which removes all minimum sentences in the singular instance where it is obvious and apparent to the judge that the defendant did not intend to commit an offence. This balances a judge's discretion with the fact that the judge would first have to find that the person did not intend to commit an offence. This will not be the case for the criminals who intend to target and would be incredibly rare, and so mandatory minimums would obtain generally. But this is a good way to balance things. Not all offences under the Act carry a mandatory minimum, and so the principle espoused is understood to some degree. What the drafters have dangerously assumed is that there is no set of circumstances which can ever arise in respect of any of the mandatory minimum offences where we might say that such a mandatory minimum is not warranted. Other countries have stepped back from mandatory minimums because of the rare but real instances where it is truly not warranted. It would be good if we could learn from their mistakes. The fight against crime cannot be won by blindly ignoring the plight of those who we seek to protect.
Chairman, we had directed persons to Section 42K of the Criminal Justice Administration Act. I think they were the 2015 amendments, which ameliorate the harshest consequences of the mandatory minimum in appropriate cases.
Thank you, Minister.
And also there is, some provisions under Section 18 of the Plea Negotiation and Agreement Act in those circumstances. So the concern has been raised and it is understood. It's not an insignificant concern, but there are existing provisions in the law that would mitigate against the worst consequences in an appropriate case.
Thank you, Minister. I had a very interesting discussion on it yesterday with someone looking into the area of criminal violence. Made a comment. I would take too much of time on my audience, but he made a comment that in the face Jamaica's unique, well, it's considered in case of high violence communities, unique in terms of the strength of our democracy, but indicating in that circumstance, the civil society will never agree with government taking strong action. I'll explain to you further, Bailey.
The next recommendation coming from, this is O'Shane, right? Yeah. He recommended that the Minister of National Security should be barred from decisions.
We dealt with that, Edward. Yeah, we dealt with that. Yeah, we can move on.
Specific to the manufacturer's license, we had, yes, Minister, we had dealt with that one. And continuing onto the other page, recommendation coming from Proactive Jamaicans. They say for offences committed by authorized person versus offences committed by unauthorized persons, multi-provisions in Part 4 do not necessarily do not have necessary carve-outs for licensed firearm holders. We suggest that the Parliamentary Council be asked by the Committee, Parliament, to prepare a table showing provisions and penalties with a column for persons without any license and the persons with a license to see if any unintended penalties are being visited on licensed firearm holders. There should also be a column showing which section number precisely provides for the difference in treatment where the difference in treatment is proposed.
We, Minister and technical team, consider this necessary. Again, the prohibited firearms is a whole section, is the first section of the bill.
Yes, in terms of the structure of the bill as it stands, Minister, that's why it was kind of formulated that way, that all of the offences applicable to prohibited weapons would fall under Part 2 and anything connected to the general Firearms Act and regulation.
This is not a necessary work to burden the CPC with again.
I think unnecessary. So, recommendation coming from Mr. O'Shane, right? The following list of items should be removed from the list of items that an individual can purchase for himself and limited quantity without requiring a permit. He's making reference to pepper spray, tactical whips, steel batons, tactical pens, small tasers. The Act as it stands now would not apply to these items.
All of these going to come under the
Offensive Weapons Act.
Offenses weapons Act. New, which is being prepared now, right?
Right.
Do we not have an Offensive Weapons Act now, which deals with knives and stuff?
We do, but amendments are in train.
Okay.
It requires major amendments, and something which come under fire. These items will come.
Another recommendation coming from O'Shane, right? The public, upon requesting writing, should be given access to the list of persons in their immediate surroundings who are licensed firearm holders. We are guaranteed the right to live in peace and security. How can we tell if we don't have the information? The process to obtain the information should require the individual to provide a reason for this information. The local police station should also be informed immediately after this request is received. Such reasons could be limited to one of the following: house surfing, establishing a business in the area, and personal security reasons, receiving threats.
Well, Chairman, while I understand a desire to know who is a licensed firearm holder in a particular locale, persons can be targeted for their firearms when it is known. It may be useful perhaps for the police to know, but given that we are automating the system and all improvements that are being made for investigative purpose, it will become much easier to check very quickly who is authorized in law to hold a firearm and who isn't. But I think I don't know that I would be in favor of letting the public know at large who is licensed to hold a firearm. We have too many examples of persons being targeted for the stealing of their firearms.
Without a doubt, Minister.
Open to hear.
Couldn't support this. I mean, you'd be setting on the person, especially with the new legislation. In fact, you'd be putting the person at greater risk, because once you improve your security apparatus and you begin to reduce the inflow of firearms illegally, etc., then the thing to do is to hold up a licensed firearm and take his gun.
Chair, I see absolutely no merit in this proposal.
Absolutely none.
Absolutely none.
It's a facetious.
I dismiss it like that because it presents a danger to persons rather than enhancing the security of the public. I don't think we need to delay ourselves in discussing it.
Indeed. Let's proceed.
Next comment coming from licensed firearm holders of Jamaica, LifeJam. In order to properly register and receive permits in Jamaica, the firearm must be marked with serial number and other numbers affixed. The Act failed to give the reasons for the marking system of privately owned firearms, clarify why 3D printed firearms that are imitation firearms are banned, while air rifles are not banned. And the Act must clearly state whether 3D printed firearms are just blocks of plastic and not capable of dispensing any round, are to be treated as imitation firearms for the purposes of this Act, and clearly defined as in the previous Firearms Act the number of rounds allowed for licensed firearm holders.
I don't need much debate here. The decision is to ensure that we have serial number marking by the Firearms Authority, which is registering both government firearms and privately owned firearms. Yes. I am not looking at reversing that. Sure. Clarify 3D firearms are firearm. I don't think you understand that. But they're made from wood or it kills.
It is.
There's no need to further differentiate. Air rifle is an air rifle, which we know is defined and how it's, and still comes under regulation. We don't need for the Act to define what a 3D firearm is. It is what it is. Not much to detail ourselves here, Minister. I don't see anything here to do ourselves. Go on.
No, Minister. Right. Continuing. The comment coming from Cornwall Bar Association. This one is in relation to mandatory minimum sentences, which we have already ventilated. Should I go through the comments again, Minister?
I don't know, the member, we have discussed this over and over. Members want to go through it again. Minister, Cornwall Bar is advocate of, is against the...
All right, I'll read it.
No, I don't think you need to have to go through this. We have discussed this several times. And what, mandatory minimum? No, the only decision we deferred was there are a number of people thought some of the mandatory was too low. And in fact, that was the decision that's the only difference we made, in that there was a view that 15 years being applied to possessions, and in the case of one, what was it now? There's another trafficking, it should be higher. That's the only issue we had. So there the law that explained to me, our legislation have some framework for sentencing, but we discussed it, I think, quite adequately and maintain our position.
Some people don't agree, Chairman.
We know there are hesitate, there are issues and questions. Yeah. Senator, you were saying?
No, I was saying even if some people have a disagreement with the mandatory sentencing for possession simplicity. Did you hear me, Chairman?
Yeah, had raised objection to the mandate for possession simplicity, right?
Yeah. Yes, and I don't resign from it.
Yeah, I remember you did raise it. No, and I recognize that it was discussed quite. In fact, that was allowed us to interrogate the issue quite thoroughly before we took a decision.
I just want the records to show that I have not changed my position in spite of the discussion.
Minister, I don't want to come because my answer is that the position that having separated the legal from the illegal, and which the illegal became prohibited, that's why we have introduced this level of sentencing for the possession of the prohibited weapon.
Sorry, Chairman. Again, I am just having a little audio challenge. I heard Member Scott Motley asking that the position she maintains her position be once again reflected on the record. But I didn't hear which part of the matrix are we?
No, we're looking at the County Bar Association, who has made a further submission on the question of minimum mandatory. And Senator Scott Motley was referring to the issue of simple possession, that they had a concern and a mandatory minimum for simple possession. All right. And I indicate we had discussed it at some length. I didn't realize we had put off or delayed in decision on that because I said the concept of this legislation was that the prohibited weapon retains the severe penalty. On the other hand, the unlicensed firearm holder would be a fixed fine and that kind of thing for, not licensing his weapon, a different issue from the prohibited weapon.
Well, Chairman, on the issue of mandatory minimum, it is an area where views vary, and there is always the legitimate concern as to whether specifying a mandatory minimum takes away the discretion of a judge to hand down a sentence that is appropriate. That is a legitimate issue for discussion. I take another view on the suggestion that it is a power grab by the legislature that is displeased with the ways in which the judiciary is exercising its discretion. It is quite permissible for a policy position to be taken in respect of certain types of matters. And in this country where the data shows that almost 8 out of 10 murder is committed, or over 8 out of 10 murders are committed with the use of firearm. And the data that we have about the challenge that the firearm poses to peace and safety and public order, all of the reasons that we have gone through, it is quite permissible to take a stance and say that persons who choose to be involved in these activities, if you are convicted at the end of a process, then this is the consequence that you will face. We have indicated that the court does have power as set out in the provisions at 42K of the Criminal Justice Administration Act and 18 of the Plea Negotiation and Agreement Act to deal with appropriate cases. I don't think that we're going to have unanimous agreement on this matter, given all of the concerns in the society.
Chair, may I respond? Oh, I'm sorry. I thought you were finished.
I'm just saying that, you know, I understand that there are going to be different views on it.
Yes, and I'm simply restating mine. I'm simply restating mine because I think there's an inherent danger in proceeding the way we have. And let me remind you that I've confined my remarks to the Section 5, which deals with possession simpliciter. I am aware of the sections which you have cited in respect of the Criminal Justice Administration Act and the Plea Negotiation Act. There are just some of us who do not believe that the accused or the convicted person should have to go through all these lengths to access justice. Now, I also want to remind you that with the amendment now that provides for the prosecution to have a right of appeal, questions of sentence which is considered to be inadequate can be addressed. But I have to bear in mind the circumstances under which one can be charged with simpliciter possession. And that is where my concern lies. The person is in possession of the weapon. There is no evidence that the person intended to use the weapon. None at all. And I am concerned about it because of the many instances that I know where persons end up being in possession of the firearm, are not able to convince a tribunal that they do not have the three requirements, which are the elements on which they can be convicted. And let us be realistic. There is a presumption of innocence. There is the view that the prosecution must prove its case. But sometimes it comes down to the accused having to defend himself. I am uncomfortable with it. I have done research into it, and I can find no article, no research which shows that mandatory sentences actually act as a deterrent. So I want my position to be recorded because there's a consistency about my position. Well, and I don't want it to be felt that I have been convinced otherwise.
Senator, you have been very clear, Senator Motley, on that, and I appreciate it. I said the most thought may given to it, and it's appearing an issue that we may end up, certainly will recall your position, but it's a matter that we may differ on. Brian Mann said the simple position you're referring to is for prohibited weapons, and I think I want to keep the two things together at this point in time, and that's why we looked at mandatory sentencing for that situation. It's also, and bear in mind with the discussion we had earlier in terms of, for example, a defense witness lying, to convict someone. So if an officer lies about it or prejudices himself in order to convict a person for this, that the consequences should be severe. Those are some of the things I think that, I think Caldwell was asking for particular provision in the case of firearms. The minister took me to the law governing that indicated they could get up to 7 years for telling a lie under someone in relation to a firearm offense and perverting the court of justice going further. So there's a level of legal remit for those who seek to falsely accuse somebody of having a firearm that they're not intending to use for criminal activity. Minister Jackson, Member Jackson, I come back.
I see Member Davis' hand was up, Chairman. Member Jamaica Davis.
Yeah, but
her hand has been up for a while, yes.
Yes, I was saying, Chairman, I fully concur with those remarks made by Senator Motley and wish to be identified with them as one who have come to, and I said never been always there, but come to the point of strong reservation, to the point of objection against these mandatory sentences. And I have seen before my own eyes in the courts where the judge herself, a female judge on this occasion, in light of all that came before her, notwithstanding the guilty verdict, had no option but to impose the minimum sentence. And when I raised the concern, she said to me, "But Mr. Jackson, you put us in this position. You and your colleagues impose the minimum sentence, that notwithstanding what is before me as evidence, I cannot mitigate the minimum sentence." So, and lastly, I want to say, it is unfortunate that many persons who advance the minimum sentence give the notion that those of us who don't support minimum sentence is in support of people convicted to go free. And I regret that.
I'd interrupt you, Minister. No, they're not that.
I'm not saying that you are.
No, definitely not. I recognize that it's a controversial
And you're not
issue.
saying that I do either, Member Jackson.
I think both yourself and Senator Motley, who have made very, very, very positive contribution to the whole discussion, and we have taken a lot of your advice on board. This one is a delicate one. I mean, much of the move to strengthen the Firearms Act has revolved around the question of sentencing. The opposite of you just raised is true. There are many times the judges say, look, we give a life sentence because that's what they give. So it is, I think Member Davis from I want to say something. Member Davis.
Thank you so much, Chair. Good morning, colleagues. I agree with the position urged by Senator Scott Motley, and I don't know whether I should point to the coincidence that I'm also a part of the Cornwall Bar, but notwithstanding that, I have seen firsthand many instances in which the position that we are now taking would not apply, how can I say this, favorably, because it is not that all the matters that come before the gun court have the same pattern. Not all the matters that come before the court for possession follow the same trend. And not all the matters that come before the gun court, the accused persons are, quote unquote, bad persons or gunmen. There are many times, many instances, and I can't enumerate them all here, where you have persons who have come upon, or that it has come upon them that they are deemed to be in possession. And I don't want to go into the legalese, but what I just want to say is that it is difficult, I guess, especially as defense attorneys, because we know firsthand that it is not simply a matter of the possession and then it's over 15 years. And it is true that there are times when the judge, having convicted the person and then having sight of a social inquiry report, who is better able to assess the person before him and then say, notwithstanding that these are the facts and notwithstanding the possession, having looked into your background, having heard from the community members, having heard from your family members, it would be unfair to impose such a sentence on you. So I understand the purpose of the sentence and the section. I too am aware of the goal that we are trying to achieve as government members, the policy that we're trying to mandate. But certainly, I think that we ought to perhaps, I'm sure that we can tweak it so that in those instances, we don't capture persons who properly. Because when we look at the goals of sentencing, we look at deterrence, we look at rehabilitation, and on that note, if it is that there are persons who are deemed to be favorable candidates, good and proper persons to benefit, then this section will not help them at all, because strictly speaking, the judge's hand will be tied. And notwithstanding the favorable report, and like our member Fitzjackson just said, the judge will just point to the section and said, listen, this is what you said. So while I don't agree with what is here, I have no choice. So I am putting on record my support for comments made by Senator Scott Motley, and that really it is notwithstanding, I must say this because I don't want it to be said that I'm going against the policy that the government is trying to achieve with the firearms and the crime and so on. I know that, but I don't think we have delved enough into those other scenarios, into those other cases where it is not a gunman or a situation where the circumstances justify the 15 years, because there are those, but we must also consider the other side. Thank you very much.
Mr. Chairman, since everybody's putting their position on the record, I would like mine put on as well. My position is the same as Senator Scott Motley, and I had suggested that the committee could have benefited from certain data, and I had I believe I sent it in writing to the clerk to the committee. It had to do with how many guilty pleas have been made under Part 1 of the Criminal Justice Administration Act, inserted in 2015 by an amendment to the Act, and to have it broken down by year and the offense to which the guilty plea was made, and how many formal plea bargaining agreements have been concluded under the Plea Negotiation and Agreements Act 2017. I believe our deliberations should be guided by the data and not purely on emotion and the pressure that an administration has to be seen to be doing something. And I just close my remarks by pointing to a case. In my first term as an MP, I then represented Southeast Clarendon, where a grandmother was convicted for possession of a firearm, which was in her house, had apparently been placed there by some grandsons that she had that were mixed up in gang activity. And because it was deemed to be in her custody, she was convicted. Now, under this act, she would have to do a minimum of 15 years, unless, something else could be proven. And I really don't think this does anything towards the deterrence of violent crime other than from a PR perspective. So I'd like my position to be recorded as well.
I take note of your position, Senator. But I want to make two comments before you move on. One, I don't know on what basis that grandmother was convicted, because she didn't have any control or anything. It's in the house. And I don't know who a defense lawyer was, but that seemed to be I don't think it's a very good case to use, because I know of many cases that have happened elsewhere, and old people are not convicted. It's a common, in fact, it's part of their modus operandi sometimes to hide firearms in old people's places, and they're not charged and convicted. So I worry about that one not in terms of the law, but in terms of the process by which she was convicted. And just in past, you're referring to your own experiences. I've had the opposite experience. I know a very classical case of a young man who I could consider was a friend, he was a student. And then after he committed a particular heinous crime, it had dismembering the individual after killing them. But he was in my office after, and he was viewed by many as a wonderful, capable individual, not a criminal type at all. It's not an emotional issue. The issue of firearms in Jamaica being used as is what is our biggest public order threat. We have remained consistently one of the highest, well, really the democracy with the highest level of murder for the last 20 years. You may go up and down with a small island between first and fourth, but we're in the top 5. And it is the use of illegal firearms to kill fellow Jamaicans. That's the statistics that you have asked for, Senator. I think it would be worth a while and ask the clerk to get them. But it won't vary. The statistics that I'm going that illegal firearms are coming in the country in large numbers and are being used to slaughter Jamaicans in plain language. And those weapons we know defined as prohibited weapons, and anyone caught with them must pay a penalty. It must be proven in court. You know, there are many ways to slide by it. There's no escape route, as far as I'm concerned. In fact, that's one of the driving forces behind getting this law, because it's very difficult to apprehend the criminal in the act of committing a crime. Proving them to commit murder is a different issue, but most of the people you're going to have, criminals you're going to find, the first charge you're going to get them in this position.
Chair, I don't know if you recall that on the first occasion when we deliberated on this matter, I had requested data that shows that mandatory sentences actually have a deterrent effect. There was a commitment to share that with the committee, and it has not yet been done. And it might be very, very helpful for members to take a look at that. In my own reading, what I have seen is that it is not useful and that in fact increases recidivism. So if there is data which is compelling to show that the objectives can be met, I would really like to be in possession of it, because I share the same concerns that you share about crime in our nation. I am equally appalled that we have this kind of murder rate. Perhaps our solutions would be different. But if I can be shown the data that says, yes, this is what has worked, that would make me reassess my position.
Well, I'm not in position of data that. The data that your colleague asked for in terms of mandatory and plea bargaining that we can get. And
respectfully clear. I asked for the data on the first occasion, and the minister did ask the technical team to get it together to share with me, and the records would show that.
Well, if such data is available, CTD, Minister, you may wish to comment. I will know. Well, I said the data is informed and I've given it. So I will get a date. If the data is available, I get it and convey it to the senators. But my position is set on the other data.
You're asking for my comments, Chairman?
Minister, you see, no, what I'm saying is that the data on mandatory sentencing is of value, and the senator may wish to, if we can get it, I'll give it to the senator. But it does affect my view. The data I am concerned about is the number of firearms out there killing people. And that data convinced me that I need mandatory sentencing. So it's too different. I'm asking the minister to make a comment.
Chairman, let me begin with a request from Senator Bunting, Member Bunting.
Hold a minute, Minister. Member Jackson, would allow the minister to make a comment. Minister
I could defer to Member Jackson, and then I could assist in your response.
No,
Chairman?
Jackson is holding his position.
I see. Chairman,
it's not only holding my position. I was seeking to give some clarification about my understanding about the data. The data that you give or is given, Chairman, is about the crime levels, that high levels of crime, the usage of firearm in the committal of that crime. That is not in dispute. And as Senator Motley said, we share the concerns about those high levels. The issue is, that being the situation, what is the remedy to cause a reduction in that? Where is the data that supports that mandatory sentence would cause that appalling data that you refer to of the high crime levels and the use of firearms? Where is the data to inform an approach? And you, with all respect, as a medical practitioner, Chairman, when you apply a treatment to a patient, it's on the basis of the performance of that drug. It's not because you feel this or you feel that, but your position is informed by reliable data, and that's all that's been asked for. Provide the data that informs the usage of mandatory sentence will contribute, or should contribute even, to the reduction of those appalling crime numbers that you made reference to.
The correspondent, but I'm asking the Minister to comment first.
Right, Chairman. A lot has been said, and I don't think that you or I will change the views or the discomfort of those members who have spoken on the matter. I guess I'm unique among membership of the committee, having spent almost a decade presiding as a judge and seeing firsthand the, the importance of each case turning on their own merits. I don't think I'm unique in that the criminal justice system is a formal system guided by rules and laws. Courts of law are unlike courts of public opinion, where no rules apply, where facts give way to perception and perception refuse to be corrected by facts. It's just two different arenas. I know that one of the requirements of judging and dealing with matters is that you do not deal with matters on emotions. It's no prejudice against anyone, no sympathy for anyone. You look at the cases, you look at the evidence. There is a standard that is set, and the standard, and there are principles of law that you have to apply to every case. Nothing is at large. All matters are dealt with within specifications, guided by rules, guided by the law. Even what you can find as a matter of fact from testimony, that is guided by the law. There are rules around hearsay, there are rules around first and second hand evidence, there are rules around admissibility, so that sometimes I find that, we pay little regard to the fact that a conviction comes at the end of a process. It is true that we live in a society where injustice rears its ugly head in so many ways. And we should never be unmindful of those who may be on the wrong end of the stick. In these cases, injustice is done parent to child, brother to sister, man to woman. We have many examples in the society of it. I am comforted by the fact that matters before the court are dealt with in accordance with rules and in accordance with the law. And that while it is human to be sympathetic, sympathy has no proper place in a court of law when decisions are being taken. If there is reasonable doubt, you acquit, even if you feel that someone may be guilty. If you are satisfied to the extent you feel sure on the evidence, you convict. When it comes to sentencing, the rules indicate that you have regard to a number of things. Starting point is what is prescribed in law. And then you look at the antecedents of the accused. You look on whether the offense represents the most egregious example. But it is quite permissible for Parliament to prescribe penalties. Now, the matter of the mandatory minimum is a policy matter that the government has taken. In Section 3, it indicates why possession is viewed the way it is, because it is the possession that forms the foundation on which the other gun offenses take place. So sometimes when we refer to possession simplicity, we may unwittingly, and I'm not saying that this is what the members who have spoken have done, we may unwittingly think of it as something simple, the simplest of the simplest. While I understand that given the high level of criminality in the society, people can be set up, I've been trying to find out why would someone deliberately take possession of a firearm that is unlicensed and unregulated, if not to use it at some appropriate time. I am not persuaded by an argument which says people will have it and they don't intend to use it. I am not persuaded by that argument at all, though I understand that people can be put in possession of it when they did not intend to be in possession. And what they do when they come into possession will determine how they are treated. And I think this law is making a framework, is providing a framework for that. So to my mind, Chairman, the data that Senator Bunting in particular has asked for, that can be obtained by the court with ease. The rest of the data, I think the technical team has been providing and the data has been informing. I would like to know of the cases where mandatory minimum has been applied, because we already have it in the jurisdiction. This is not a new matter for the Jamaican jurisdiction. How many cases have the judges certified that had a mandatory minimum sentence not been prescribed, they would have applied another sentence? I'd be happy to hear that, as well as the other bit of it. But I think, Chairman, at the end of the day, as a minister with portfolio responsibility for it, this is a policy that was approved by Cabinet, and it is a policy position of the law set out that the administration takes a view that the possession provides the foundation for all other gun offenses to take place. Because if you don't have it, you can't possess it, you can't use it. And if you come into it in circumstances, provide the information, turn it over, and you would be treated differently. I have to give the benefit of the doubt to the judges who convict persons that they were satisfied to the extent that they felt sure of guilt. In the same way, notwithstanding any concern that I may have, when you hear stories about people being acquitted, I will give the benefit of the doubt to the judge that there was reasonable doubt and they acquitted in the circumstances. So, Chairman, what data is to be had and provided, the technical team will provide it and we deal with it, because generally I share the view that we don't take decisions on emotions. And I don't think that the policy position that was taken by the administration was taken on emotion or being sharply responsive. I accept that we will have different views on the matter, because injustice rears its ugly head in this society in any of many forms. But when you go through court, you have to be subject to the rules. And fortunately, even though it takes time, but due process is due process. You will have to go through a process to get a result. Even when someone pleads guilty, there is still a process that you go through, albeit a shortened one, before you get to a conviction as a result of a plea of guilty. So admittedly, I'm not unsympathetic, but I do take a different perspective on these matters.
Thank you, Minister. I think you have made it very clear. I understand it's a process to get to guilty. if somebody has, to being defined as guilty, it's not the police who makes you guilty or just arbitrarily define someone as being guilty. I think Senator Scott might want to come back, and I will certainly allow to come in.
I want to make, before you move on, Chair, may I make one last comment?
Sure,
and to say how appreciative I am of the minister's views as to how the courts functions and the rules which they adhere to. I understand how the system works very, very well, and I have great respect for the system. And it is precisely because of this and because of my experience why I believe that legislators must act without emotion, that no laws must be driven by passion, by how they feel or how the society feels, that legislators have a duty to balance various interests. And what better way to do so than to use data to drive the legislation, especially in terms of sentencing. So having listened to her, I am sure that all the data is easily available, because I do not believe that the cabinet would have formulated this significant policy without being data-driven, and I certainly look forward to seeing it.
Thanks to the data that Senator Bunting asked for, I think we'll get those. I'm not sure what data we're asking to reach the mandatory sentencing. Again, I go back to a discussion that someone studying this.
Well, Chairman, mandatory sentence is already in the jurisdiction, so we can find out from the court how many cases in which a mandatory minimum has been applied and where the court felt that but for their hands being tied, and so they utilize the law that is there. I'd be interested in that data too.
I hear you, Minister, but there are not many things that you can compare with the homicide rate with firearms, and you have to compare apples with apples. Not, where mandatory sentences exist for other things under different circumstances. And in fact, I said that again in one of the research work we're doing on yesterday, that discussion where one was pointing out the question of mandatory and the treatment of firearms in the use of violence and homicide. There's no other country with a parallel like this. There's nowhere to find data that can justify or not justify what we're doing. In fact, it was interesting, and not because it coincided with my own thinking, when they said this country has a better judiciary and a stronger democratic system than any other country that even approaches the level of violence we have. We are trying to do something that is absolutely unique. So someone who has been doing significant work across the globe, in Latin America and elsewhere, and violence and gun violence in particular. So, that is, and I agree with that sentiment. It's unique in terms of the situation we're faced with firearm as the use of committing acts of violence in Jamaica. And the possession that you refer to is the possession of a prohibited weapon. It doesn't matter the possession of a firearm. And the very possession itself is what casts fear in the community. The shooting, the killings is what currently, engages the wider society. But in the community where the guns exist, it's the possession that creates the fear. It's the possession that creates the sense of lack of security. It's the possession that people will not go to the police. It's the possession where people will not even provide the kind of evidence that is required in court on many occasions. Possession is the root of gun violence, and if you disembowel this particular possession, we disembowel entire legislation. That's why the government took the policy position. Bunting coming back in the picture? No. The data, I said, the data he has asked for is relevant, and you can get that data. But the policy position, I said, is taken. We'll discuss it more, and the members have brought serious concern. I don't think any of them were not noted by members by the government in taking this decision. But I said, quite frankly, in terms of the communities that are impacted by gun and gun violence, possession is maybe more, is the root of the issue. The whole community is imprisoned by people by simply having possession. But we get the data for Senator Bunting. We move on the
Chairman, I think it may be worth reiterating that in formulating the law and in settling the policy, these are matters that were also taken into consideration, and the entire framework of the law is to be considered, even as we come to it from different perspectives and different angles. We appreciate and understand that persons may come into possession of the firearm contrary to law in circumstances where, they had no intention to do so. And that is why an avenue is presented for them to provide the information and turnover. And we also know any of the many complaints that can be raised about whether that is so or not. But we are not going to build out the new society that we need to build out if we are not going to ensure that proper and accountable relationships exist between the state and citizen and agents of the state. We cannot have it always. So that we too, in particular, those of us who are elected, not that the special understanding is unique to us. I'm just saying in particular, we see and we hear firsthand the issues of injustice in the same way of the issues of crime, and we see. But if you don't have the firearm, you can't use it to do anything else. Who can kill someone using a firearm if he's not in possession of it? Who can shoot someone with intent to cause grievous bodily harm and in fact cause grievous bodily harm if you're not in possession of it? Who can use a firearm to intimidate another and dominate a space if you are not in possession of it? Or in sometimes say that you have it. I'm just saying, Chairman, I do take a different view on these matters. Always, I am fair to people, always.
Thank you, Minister, for that very strong comment. I say, the other side of the coin of all members are raised of injustice and conviction of individuals who may be. The other side, I think, I have confidence in Jamaican justice system. There are issues that they have confidence in the system emerging that we are building to ensure that justice is done in these situations. I refer to the uniqueness of our position, but I think we also unique to the extent that we have one of the better law enforcement judicial system among countries that suffer high levels of violence. And I find it the statistics that we have interest, how many people we could pick out that judges feel they have convicted. Or, it would have to be a guilty plea, because if there's a trial, there's the evidence. But how many people have had to plead guilty to a possession who were not, because they found themselves inadvertently in the possession of a firearm? And that we have some interesting data. Now, in the face of a 15-year minimum, I don't expect people just plead guilty, just like that. So the trial of the proceed.
Chairman, like I said, sorry to disturb you, in the request for the data from the court, specifically, since we have provisions in the law of the cases where a mandatory minimum sentence has been handed down, in how many of those cases did the judge provide a certificate to go up? Whether they chose to go up or not is another matter, or where the records show that the judge felt that their hands were tied. Because we hear a lot of anecdotal evidence, and I have no doubt that in some cases it does happen. But I don't know the extent, and it could shed some further light.
Certainly. Well, we'll ask the technical team to contact the relevant contacts in the judiciary and get the data. All right, go ahead.
Continuing, looking at the recommendation coming from licensed firearm owner of Jamaica, LifeJam, in respect of Clause 2 interpretation, they're recommending that the term firearm, or it is proposed that Section 2 submit a more comprehensive definition of the word firearm as compared to the previous act, which made a detailed definition at Section 5. I question whether or not they're actually making reference to imitation firearm that had a detailed definition at Section 25. I'm not sure what exactly they're asking for here.
What is substance of the request? I don't. What's the substance?
If it is that they're asking for a revision in the definition of firearm, the definition of firearm as it stands now, it's very comprehensive. It's actually more comprehensive than it is in the current act. So I'm not sure the basis of their recommendation.
There's something CPC would wish to comment on. I'm not sure there's any change required here from what we have.
So much here, I'm with Mr. Bailey on this.
Continuing, recommendation coming from JDF. So the following is being proposed in relation to Section 2. The following definition should be added to the definition section. They're recommending that a definition be given to the word accessories, and accessories refers to parts of a firearm which may enhance or increase the operational efficiency and or accuracy of a firearm, but will not constitute any of the major or minor internal parts thereof, such as, but not limited to, holographic sights, night sights, finishing of exterior or springs which affect trigger pressure. Their other recommendation is to include, in respect of imitation firearm, their definition or proposed definition is that is so substantially similar in appearance to a real firearm as to lead a reasonable person to believe that such imitation firearm is a real firearm. Their next recommendation is a definition for unlicensed firearm, and an unlicensed firearm is a firearm which has never been issued a permit or certificate to the individual whose possession it is found in, distinct from a licensed firearm whose permit or license has expired or whose owner has committed an illegal act with it. The person being found in possession of or committing a crime with an unlicensed firearm should be sentenced or should face a more stringent penal sanction than an individual whose licensed firearm permit has merely expired. So what we can do is just address these. There's a long list of recommendations in respect of Section 2. So going back to their proposal in relation to the inclusion of accessories. One moment. So we had agreed to look back at including a definition for assorted parts, which would essentially be accessories in this context. Assorted parts. So this point is taken from JD.
This you want to come in, let me. CPC, you're coming in? No.
No, Chair.
Okay. Go ahead, Mr. Bailey.
So accessories, that is accepted. But in terms of their proposed definition, we're not necessarily in agreement with the proposed definition for imitation firearm or for unlicensed firearm, because we have already gone through the lens of defining a prohibited weapon or a prohibited firearm that would cover unlicensed firearm. As it concerns imitation firearm, we already have a definition that we believe is sufficiently comprehensive. Continuing.
Continue.
They've also said that the definition of parts and component parts be broken down into the following. 1, major part or component of a firearm, which refers to the barrel, slide, frame receiver, cylinder, or the bolt assembly. The term also includes any part or thing designed and intended for use in converting a semi-automatic to a burst or full automatic firearm, to include, but not limited to, bump stocks, Glock chip that converts Glocks into full auto. Second, minor parts of a firearm refers to the parts of a firearm other than the major parts, which are necessary to affect the complete action of expelling a projectile by way of combustion, except those classified as accessories. Illegal firearm refers to an unregistered firearm or a firearm with an obliterated serial number, or a semi-automatic firearm which has been altered to fire fully automatic, a firearm which has been lost or stolen, illegally manufactured or registered lawful firearms in the possession of an individual other than the licensee, save and except in the limited circumstances of demonstration use at a registered approved range.
So recall our discussions, Chairman, to look back, having had the benefit of the presentation from the ISLM at the fulsome definition of parts and components. So that recommendation is now being properly refined to send back to the CPC. We do not agree with the definitions that they are proposing for the inclusion of minor parts, nor for illegal firearm, for the very reason that Mr. Bailey pointed out in respect of a definition already in the legislation for prohibited firearm.
All right, we can go with that. Continue, Mr. Bailey. We accept that.
Minister, just to point out, though, that in relation to the definition that they have proposed for unlicensed firearm, though we have a definition for prohibited firearm, we can look to see what they have suggested to see if there's anything that we should incorporate in our definition of prohibited firearm, just to make sure that it's as comprehensive as possible. Continuing.
Yeah.
Recommendation coming from Cornwall Bar Association to replace the word barreled.
Sorry, I think that this might have been an error. I'm looking at the submission from Cornwall Bar. They do not have a recommendation in respect of Section 2. So I think this might have been an error in translation. So you can skip over that, Mr. Bailey.
Right, looking at the recommendation coming from Proactive Jamaicans. So they're recommending a definition be included for digital blueprint. For the definition of digital blueprint in Section 2, the suggested amendment is digital blueprint means any CAD file or other type of electronic data file which contains specific instructions for a computer designed to automate the manufacture of a firearm. The rationale: the current definition is too wide and would include a wide array of various types of technical drawings which explain the components of a firearm. For example, such a blueprint was included in FLA training manual available for download from the FLA's very own website. Many other similar blueprints and drawings are contained in user manuals and packaged with every firearm sold, or on the manufacturer's website, or even on T-shirts and posters. In fact, such detailed blueprints are often required by gunsmiths to enable them to repair and order parts. Clearly, this is not what is intended. What we believe was intended is properly defined CAD drawings for 3D printing or CNC milling. So, Minister, this recommendation is one that we are looking at to see whether or not it's absolutely necessary to accept, because as it stands now, we already have a definition for 3D firearm, and it makes reference to digital blueprint, and it is now intended that digital blueprint be taken in its ordinary meaning, but we're looking back to see whether or not it's absolutely necessary to take on this recommendation to include a definition for digital blueprint.
All right. So it's really a review to see if we have covered it already. Yeah.
Recommendation coming from Canute Boucher. Consider including the term projectile in the definition imitation firearm and 3D printed firearm. This one was not taken. Projectile is covered in our definition of ammunition.
What are you referring to?
Continue.
Boucher.
Recommendation.
Consider including projectile as a definition.
They're asking us to consider including projectile in our definition of 3D firearm and imitation firearm, but projectile would not be appropriate because it's already included in our definition of ammunition.
Move on.
A recommendation.
We're not doing. We'll be closing off at 1 o'clock sharp. So finishing.
Okay. Recommendation coming from JDF. The following definitions are. We have missed that. Okay, next page. Armor. Definition of armor. Recommendation coming from JDF. It is proposed that persons employed to the JDF as ammunition technicians and explosives ordnance disposal personnel be exempted from this requirement whilst acting in their official capacity. The rationale: we accept the provision of Section 111. However, we are desirous of having this specific exemption in light of the fact that our JDF personnel are often rotated from base to base and post to post. The JDF would request that the Minister grant to the CDS the power to designate those members of the JDF carrying out the aforementioned functions as armorer.
So just a reminder, Chairman, that the Act really does not apply to the JDF or the security forces. So I'm not sure of the mischief that's been trying to solve. Right.
Continue. Definition of the term modification. It is recommended that licensed firearm owners be permitted to do basic repairs to their own firearms to include...
Chairman, may I just Chairman, may I just suggest that we be guided by some of the presentation from the ACP, from the expert.
It is proposed that persons employed to the JDF as ammunition technicians and explosives ordnance disposal personnel. Continuing.
Minister. Mr. Ford, you're saying?
Chair, should I continue?
Not hearing her. Minister Ford?
Looks like the minister is having some connection problems, Chairman.
Yes. Interconnectivity.
Continuing. For the definition of modification, it is recommended that a licensed firearm owner be permitted to do basic repairs to their own firearms to include the changing of sights, the installation of holographic sights, slip-on rubber sleeves, and the color of the firearm. This can be affected by normal wear and tear and rust. The rationale for this recommendation is that it is submitted that the definition could cause undue hardship affecting licensed firearm holders. The section as drafted potentially creates criminal offense for relatively benign activities that persons would normally carry out as routine maintenance, repairs, and upgrades, which do not affect ballistic signatures of the firearm. Therefore, it does not compromise the evidential value. Section 13 of the Act, it is submitted, adequately addresses the mischief which the drafter intends to combat, which is the illegal altering of the ballistic signature and/or modification and/or conversion of a firearm. It could not be that the drafters intended to criminalize a licensed firearm holder tightening a loose screw or adjusting a sight that is off or clearing a jammed slide. So, Minister, it was taken that we would have looked at our definition of modification to see how we could tighten it to ensure that we weren't unintentionally covering individuals who would make basic.
I think DSP, made some very. Bernard, coming to relevant, including the color. So be careful how much we do there. I think he gave a very thorough outline of what impacts the cat and what should be changed. So, but certainly could review that, but we do it quickly. Yes, just make sure we cover everything.
Sorry, Chairman, just to add that I believe when we had reviewed the bill, we did not identify an offense of modification in general, right? The offense is specific at section 13, and it outlines the elements, that is, to do anything to a firearm which alters the ballistic signature, to convert into a firearm anything which is not a firearm, or to convert into a prohibited weapon anything that is not a prohibited weapon. So the simple modifications that are being referred to here would not fall under that. So therefore, there would not be a criminal offense.
Thank you.
Continuing, we're looking at proactive Jamaicans. The recommendation include a definition of, or in our definition of firearm shooting range, that we delete the word specialized and archery for the definition of firearm shooting range. The rationale is a firearm shooting range may also include facilities for a variety of other sporting activities. In addition, a bow is not a barreled weapon and does not meet the definition of firearm, nor is it a firearm, and therefore cannot be regulated by the Firearms Act. Their recommendation: amend the definition of firearm shooting range as follows. I believe this was a...
Yes. It was to delete the words specialized and archery.
Chair.
Go ahead.
Chair, this is Nadine Wilkins from the LRD. Paul, I just want to go back to modification. At section 42, it prevents the goldsmith, the holder of a goldsmith license, from accepting delivery of any firearm for the purpose of effecting modification unless the person who produces the firearm has a license under Part 5. So I'm not sure which one of the Part 5 licenses would apply in this case. So it's not just an issue of offenses and lethal. I think they would be caught by 42, where they'd be required to obtain a permit to carry out simple functions to do with the firearm, which would be simple or routine functions. So when you're looking at it, I'm just pointing that out so you could look at that as well, when you're looking back at how modification is used in the bill.
Noted, Ms. Wilkins. Thank you.
Continue.
So we accept the recommendation to remove the word specialized and archery from the definition of firearm shooting range. So this recommendation is accepted. Next recommendation coming from Proactive Jamaicans. It is suggested to have a definition of additional class of permit, this being the firearm used as visitor's permit, means a permit authorizing a visitor to the island to import, possess, and export a firearm within a limited period for the purpose of participating in sport shooting or for conducting specialized firearm training. The rationale: Jamaica has a rich history of successfully hosting visitors to the island for firearm-related sporting events and training. This suggested class of permits seeks to consolidate a variety of permits, certificates, and licenses into one class that allows for these visitors to bring their firearms into the country and participate in the previously mentioned activities. In response to this recommendation, Chair, we don't believe it is necessary because we already have authorization in respect of this specific situation where there's an individual who is coming into the country to participate in sports shooting or activities. So we already have treatment of this specific situation. Page 12. Page 12, and it's a recommendation coming from Proactive Jamaicans.
Can you just remind me here of the section that permits it? I'm aware that we have made provision for it, but could you remind me of the section under which we have done so?
Senator Martin.
Could you go again, please? Sorry, I missed that.
I was saying that I am aware that provision has been made. I just wanted a quick reminder.
Oh, sure. It is section 62, the special certificate.
Thank you.
Continuing, we're at on page 13, recommendation coming from...
Just for interest, I guess that's a section we look at if we're looking at, this is for firearms for sporting purposes. If we're bringing in firearms or imitation firearms for filming purposes, would come under this section as well.
Yes, Minister.
That's what we need to look at. All right, go ahead.
It's a recommendation. It is suggested to insert a new definition after holder, definition for host firearm, a firearm that is capable of being fitted with and operating interchangeable barrels or barrel insert, each of a different caliber. The rationale for this proposal is firearms capable of operating with multiple calibers are becoming increasingly common, especially for participation within various shooting sports. Minister, this proposal was not accepted because we believe what we have now in the firearms bill is sufficient. It is already accepted that for certain firearms it can change out aspects of it. Continuing, same Proactive Jamaicans. They are proposing a definition for imitation firearm. The suggested amendment is imitation firearm means anything which has the appearance of being a firearm but is not a firearm, whether or not such imitation firearm is capable of discharging a bullet or other missile and is possessed with the intention to pass it off as a real firearm. The rationale: there are many innocent everyday items which may have the appearance of being a firearm but are not a firearm, from massager guns for sore muscles to hot air guns for plastic welding work to impact drivers, small drills, etc. Similarly, children's plastic water guns or brightly colored Nerf guns at a birthday party would all be prosecuted as imitation firearm. So just to note that there is no offense for mere possession of imitation firearm. The offense is the utilization of the imitation firearm in furtherance of a felony. So there is no real harm or danger here in retaining the definition of firearm as it stands now. Continuing, they have also made a proposal in respect of the definition of modification. For a part of appreciating that we have already given assurance to revise our definition of modification, that we can move past that recommendation, going into the next one for recommendation for definition of prohibited weapon. In section 2, for the term prohibited weapon, part E, the suggested amendment is any imitation of any weapon or device referred to in any of the paragraphs B to C. Apologies. In section 2, for the term prohibited weapon, part E, the suggested amendment is any imitation of any weapon or device referred to in any of the paragraphs. B to C. The rationale, there are many innocent everyday items which may have their... I believe this was not copied properly. Apologies, Minister. There seems to be some confusion in the document itself, because one aspect is talking about amending the definition of prohibited weapon, and then the rationale here is the rationale for a different definition for imitation firearm. We'll continue. Definition for property. It is suggested to delete the words other than a conveyance in our definition of property. The rationale, a conveyance previously defined as included any vehicle, vessel, aircraft, or other means of transport, also represents personal property. So in response to this recommendation, it is intended for us to maintain that distinction between property and conveyance because of how it's treated throughout the bill. There are specific offenses connected to conveyance, and there are also specific offenses connected to property that necessarily exclude conveyance in that case. Minister, looking at the comments that they had provided, Proactive Jamaicans had provided, and not looking at the matrix, just to determine what exactly was being recommended in relation to prohibited weapon. So their suggested amendment is any imitation of any weapon or device referred to in any paragraphs B to C possessed with the intent to pass it off as a real weapon or device as aforementioned. Their rationale is there are many innocent or everyday items which may have the appearance of being a firearm but are not a firearm. It's the same. The suggested refinement is to include the words to the effect that the article is possessed with the intent to pass it off as a firearm with malicious intent. So this recommendation is not accepted because we're not seeking to get into the intention behind the possession of the imitation firearm. Continuing, the following are proposed for Section 3. We're now at Section 3 of the bill, objects. Insert additional definition for weapon. Weapon means any device made or adapted for use of causing injury to the person, or which is intended by the person having such article with him to cause such injury. In Section 3B, to insert the words, promote the effective and transparent management of the regulation. So to promote the effective and transparent management and regulation of the firearm industry, to create another subparagraph which would read, to provide a framework which respects and promotes the legitimate, diverse, and reasonable uses of firearms. Their rationale, by creating a new subsection F, we seek to capture the very necessary objectives of regulating and respecting legitimate uses. The preamble to the objectives and indeed the whole Act seems to be disproportionately focused on crime. While it is necessary to criminalize many things, the reality is that it is the purview of the JCF and the courts and social intervention policies from Parliament that tackle crime. The FLA is a regulator of legal firearms, and the diverse legal uses must be acknowledged.
Not hearing you, Mr. Bailey.
Can you hear me now, Minister?
Yes.
Okay. So their proposal for the inclusion of a definition for weapon was not accepted. We believe the definitions that we have now are sufficient. We already defined prohibited weapon. We defined prohibited firearm, for instance. As it concerns specifically the recommendation for the amendment to the objects, the point is taken that the Act also concerns itself with the regulation of the firearm industry. But as it stands, the objects at Section 3 also concerns itself with the regulation. But when we look at Section 3, it says, provide for and promote the effective management and regulation of the firearm industry through the establishment of a robust licensing regime. And that is handled in Part 4 and Part 5 of the bills. I'm not necessarily sure why this point is being made as if the Act totally overlooks or excludes reference to the regulatory aspect of this whole regime.
So I think the substance of their proposal was to introduce the word transparent after effective, but I propose that effective also include transparent management. So I'm not sure that it is absolutely necessary for us to make this amendment to the objects of the Act, which was effectively debated and agreed at legislation committee.
One more second.
There was recommendation coming from Kanut Bashir in relation to Clause 2 interpretation. He had asked, consider amending the definition of the term relevant authority to speak to the board and establish a separate definition of the term final authority to speak to the minister. Rationale, this will distinguish between the board and the minister clearly in the cases in which it will be required to act. So back to page 8, we're looking at the recommendation coming from Kanut Bashir. It's at the end of page 8.
What we dealt with that already? Page 8.
Yes, sir. I'd skipped over that recommendation. Kanut Bashir. So this recommendation was not accepted because it was intentional to define relevant authority to include the board and the minister. The way it is used throughout the bill is that relevant authorities, as the case may be, because it may be making reference to the minister or it may be making reference to the board. So it's necessary for it to be defined as it stands now.
In the new bill, I don't see really any potential conflict between confusion between minister and board.
No, there would not be.
There would be. Jamaica custom we did, so move on to continue, Mr. Bailey.
So
said
we were looking at, so we did customs.
No, we did customs.
Yes. So
orally.
We're now back to clause 3, looking at the other recommendations.
Which one?
So we covered clause 3, covered no recommendations in respect of clause 4. Next recommendation is in respect of clause 6.
No,
this is on page 17, Minister.
17?
17.
Yeah.
So the recommendation coming from licensed firearm holders of Jamaica, Life Jam, in respect of stockpile in clause 6. They say for section 6.1, it is recommended to clearly define, as in the previous Firearms Act, the number of rounds allowed for licensed firearm holders. The Act must clearly state that section 6.1b refers to stockpiling of 50 or more illegal rounds, and that it is not encapsulating rounds obtained lawfully by licensed firearm holders. Rationale, we find that this section is too vague to be accepted into law. whether a common citizen who has no permission to bear arms is found to be in possession of one single round of ammunition or 50 rounds by comparison, that citizen is still in breach of the law and will face the court. The Act fails to mention whether possession of 50 rounds of ammunition makes a licensed firearm holder with a requisite license if they are also in breach of Section 6. And just to point out that Section 4 makes it clear that if there is a license in respect of the firearm or ammunition, that Part 2 would not apply, so that individual would not be found guilty of Section 6 of stockpiling if it is that they're in possession of 50 rounds of ammunition for which they have a license for it. So their concern is actually resolved by Section 4.
I just have a clarification question.
Right, Senator.
In the case of a licensed firearm holder who is allowed 50 rounds per year, let us say year one, he gets a 50 rounds. He, during the course of the year, fires 40 at a range and has 10 in the magazine. He then, the second year, he then gets 50 more rounds. He now actually has 60 rounds in his possession. Would he be subject to this stockpiling?
No, Senator, because he would have an authorization in respect of it. So with stockpiling under 6, as outlined in Clause 4, if it is that he has the authorization, Section 6 would not apply.
So as long as he doesn't purchase more than 50 rounds per year, he could accumulate that 50 to 200 or 300?
If the authorization allows for that.
My recollection is the authorization doesn't, as it is presently in the current legislation, doesn't speak to stockpiling. It does speak to the, or it doesn't speak to the inventory. It just speaks to the annual annual purchase permission.
Yeah, Senator, it doesn't. Nothing speaks that. If you buy 50, I know you need to buy another 50 of 100. That would not
but
become.
That 100 was legally acquired.
But you buy them with it's an authorized from an authorized dealer with authorization, so there could be no breach there.
Okay, I just wanted to make sure I was clear on it. Thank you.
No, I'm with you on that one. Right.
Recommendation coming from Jamaica. Oh, we had looked at Jamaica Rifle Association. Continuing.
Really, the next line is really. We can stop here. We go to section line 9, I think. It's 1 o'clock. It's 5 to 1. No, I think we'll have to stop here and reconvene next Thursday. If you can get the data that Mr. Bunting asked, Senator Bunting asked for, by then, please. But we'll begin at page 18, manufacturer. That's where the next suggestion comes in from licensed firearm holder. And next week, Thursday, we follow the same pattern. It's a hybrid for the next meeting. And we begin at page 9, page 18, section 9, right? Okay. I hope we can go to a little bit faster, but I know we have a few things holding. All right. What is this? That's Thursday, same time, same time period, all day. Eh? You want to start at 9? No. What is the time frame you have? Let's thank all the members. We're going to first continue on a hybrid system. There have been some challenge, especially for the technical team here communicating from our connection. So when that breaks, we have a major problem. So we're going to keep technical, but we'll do it hybrid. So I'll be operating from here next Thursday, but we'll maintain the connectivity. So those who can join who wish to join online will so do. Let me thank all the members again. We're on another run. I think we have all the Thursdays reserved. And for about 3 weeks, And then we do a Thursday, Wednesday, Thursday.
And Chairman, on behalf of those who have been advocating for the hybrid option, I want to thank yourself and the technical team for facilitating it.
It is said that hybrid is always of the better quality, right? You're a farmer, right? All right.
Sorry, excuse me, Chairman, can I just confirm it's at 10 a.m.? I wasn't hearing clearly.
Yeah, that's correct. They also suggest to go a bit early, but we figure 10 a.m. is still the starting time.
Thank you.
Right. Thank you, SG.
So move, Mr. Chairman.
Next week could be an all day, see if we can get through all of this. We have the Parliament for the day. We do it hybrid still. All right. Thank you so much. I take your notes of adjournment, Senator. Thank you.
Very well, Chairman. Good afternoon, everyone.
Have a good evening, all of you. Ministers here in the good city with Senator.
We talk later, TPM. Yes.
Despite of our promise, it's still the good city, the better city.
Coding and programming share the same language.